A victory for black women as the Constitutional Court today ruled against an apartheid-era law that automatically entered marriages of black couples before 1988 to be out of community of property. To give us context and help us understand this is Legal Resource Center Regional Director Sharita Samuel. Sharita, good evening and thank you for your time here on the Newsfeed Late Night. Just explain to us, how did this default position arise?
This default position arose out of the application of Section 22(6) of the Black Administration Act, which, as we all know, was apartheid legislation. Unfortunately, attempts in 1984 and 1986 to ameliorate this hardship placed the burden on the parties to black marriages. So that is how it was apparently overlooked and still existed in our statute up to this day.
And then to the extent that it existed in our statute, what did it mean? What was the impact thereof?
The impact of this law was that women and men, such as my client, Ms. Agnes Sithole, were automatically married out of community of property, which meant that my client could not lay a claim to any of the assets acquired by the joint estate for the duration of the marriage. So when her husband threatened to sell their family home, she was helpless because she was informed by the domestic violence court that she actually had no claim to the property, that she was not the owner of the property, that it was owned solely by her husband because of the application of Section 22(6), which had been retained in the Matrimonial Property Act.
So how significant is this judgment? I mean, does it automatically mean now that all marriages before the 1988 amendment are now deemed a community of property?
Precisely. That is what it means. It places no burden on women such as my client and the estimated 400,000 women like her. It places no burden on them to do anything. So they are automatically married in community of property with immediate effect.
And what about those who are opting to marry out of a community of property? Would they need to then notify the Department of Home Affairs accordingly?
Yes. So those that had been married out of community of property will then have that recorded with the Department of Home Affairs.
Now, any person here possibly who has some kind of interest, and maybe they did lose a property years ago when, of course, before this judgment came to pass, what recourse do they have?
Well, all acts or omissions that may have had legal consequences as a result of this legislation remain unchanged. And any party that may decide that they are prejudiced by it are then permitted to bring an application to the High Court in order to remedy the prejudice that they allege may be caused as a result of this order that has been granted by the Constitutional Court. Yeah. So the court has gone to the extent of protecting or anticipating people that may claim prejudice, but at the same time, it has created the default position for the affected women.
All right, then, that is very clear there, Sharita. I mean, it is indeed a huge victory. And how are these processes, I suppose, going to work towards transforming generally issues of gender in South Africa and empowering women more in terms of decision-making in their marriages?
This judgment was primarily about women's access and control to property. Controlling such access is a form of extreme oppression. And what distinguished this class of women is that only this class of women were actually deprived of the right to stake a claim to property that they had helped acquire by different means for the duration of their marriage. So this kind of judgment grants substantive equality. It remedies oppression that has carried over post-Constitution and remains on our statute book. And it's a great advancement for women such as Mrs. Sithole and the similarly affected women. thing about this judgment, it was the third of a trilogy of cases that the Legal Resources Centre has litigated over almost 15 years in order to extend the protection of access and control of property to this particular class of African elderly married women. And in all three cases, it was allegedly because their positions and the protections that ought to have been extended to them was overlooked. And that is unacceptable 25 years into democracy. They are one of the most vulnerable groups in our society who have suffered some of the most severe form of oppression over many decades. My client was married over 47 years, and at the age of 70 or 71, she bore the risk of being rendered homeless and destitute because of a law such as this that had remained on the statute book. It forced her to bring interminable number of court applications that she could ill afford until she came to the Legal Resources Centre, which obviously offered her free legal services and representation. And the important thing about the third of this trilogy of cases was that it was argued by the same advocate, Jeff Butlander, who understood what we were trying to articulate about how depriving women in this class of access to and control of property was something that made equality a laughable concept for them. And people are very fond of saying many words on many platforms, but how much is being done to bring remedial equality to affected people? But this particular class of women was left completely unprotected, almost as though the law did not consider them worthy of the same respect and protection extended to every other race of women.
Yeah.
And it was something that is unacceptable today. And we really salute our client. We salute her for her strength and her courage in what are very patriarchal structures to stand up and to fight on behalf of herself and on behalf of all the other women that she insisted that the Legal Resources Centre bring this case in the name of.
Sharita, I appreciate your time. Thank you very much for joining us tonight. That is the Legal Resources Centre Regional Director there, Sharita Samuel, here on the Newsfeed Late Night. A significant judgment indeed obtained by the Legal Resource Centre on behalf of Ms. Agnes Sithole and 400,000 other elderly black women in South Africa. We continue